And in case you're unfamiliar, that is the People's Court theme song. And one of the segments I wanted to do this week, which is a little different than what we usually do, because I don't really like to get into the legalese of the court system, because I think it gets convoluted, and I think that there's a way that you can explain things that are better. So one of the things I've been thinking about is because one of the things that we talk about in organized crime, especially with cases and indictments, is you always hear the tapes, the tapes, the tapes, the tapes. And you've always heard me say on shows, especially when it comes to like the Joey Merlino trial and stuff like that, that the judge would not allow tapes of the informants in those cases. And I've always said I never understood what is the discerning evidence that would suggest that it shouldn't be admissible. Now, I agree. An informant talking about hemorrhoids, oversized nipples, whatever his personal issues might be. I can understand why certain things that an informant is caught saying can be relegated to inadmissible. However, there is a tenet when it comes to Brady material and Brady and Giglio material, Jenks Act stuff. It's all encompassing in a RICO case, in a federal case. And so I wanted to talk today about the tapes. There's going to be a little legalese, but I think it's going to make sense, and then I'll sort of wrap it up in the end, because I think a lot of people talk about the tapes, but they don't understand the legal foundation as to what's admissible and what isn't. So I'm hoping today that you'll understand that. And then I'm going to sort of make a counterpoint as to why in certain cases they should have been allowed. And I think the best way to do it is to leave you with this opening question. Is we know that in organized crime cases, very often, more often than not, those that are testifying against gangsters or their contemporaries have in most cases committed more dangerous and sickening crimes than the men they're testifying against. However, when it comes to tapes, there are people that, I'll use the Joey Merlino case. J.R. Rubio said that he had attempted several times, and he says this on a recorded message, that repeatedly he had tried to get Joey Merlino involved in crimes, and he says he will not do it. Now, he will not get involved in any illegal activity whatsoever. That is incumbent to play in a court of law, because it proves that the defendant in a case has been not caught. I hate to use the word caught, but is basically saying, I'm not getting involved in no crimes. Don't even talk to me about a crime. That lends itself to a defense. But more often than not, judges sort of have a loose playbook when it comes to this, but it's even deeper than that, because the prosecution can decide what they want to admit and what they don't. And then the legal battle begins between the prosecution and the defense about whether or not that tape is valid. And I think in the case of like J.R. Rubio, I think a lot of the things that he said caught on wiretaps show a propensity to not tell the truth. It showed a propensity that Joey Merlino, in fact, at that time, was not involved in the conspiracy that they were trying to throw into his lap. I'm not defending Joey. I'm not saying he's a fucking saint. I'm not saying that he wasn't involved in X, Y, and Z. But what I'm telling you is, from the legal standpoint of a defense, that tape would be helpful. That tape would be helpful when he is caught saying, I hope this cocksucker gets 1,000 years. I hate him. I blame him for everything that I'm going through. But the reality of that is, if J.R. Rubio's never caught selling drugs on his own as a part of a different faction in another state, then he doesn't end up going down to Florida trying to get Joey up in charges. I think an American jury should have heard that, because it shows that Rubio was a liar. It shows that he could not take any responsibility for his actions and wanted to lay it on the lap of another man, which if a jury hears that, they might say, wow, it looks like he's trying to get underneath his own charges and forcefully trying to manipulate the system. And then when you go to his phone that he factory reset, that shows a culpability. Now, his excuse was, well, I had porn on there. Oh, come on. You deleted the part of your phone You factory reset your phone because there's things that you were doing you didn't want them to find out about, crimes or whatever the case may be. That is another thing that sort of goes in a complicity to lie. And that's what I wanted to talk about today. So Brady material is derived from the United States Supreme Court in the case Brady versus Maryland in 1963. It established a rule that the prosecution has a constitutional duty of due process to disclose material evidence favorable to a defendant, meaning anything that they have on these fucking tapes that could help the defense, they have a duty to provide the courts. However, later in the State versus Carter, the court found that such evidence should be, number one, material to the issue and not merely cumulative or impeaching or contradictory. That's a problem with the law. Okay, because what number one is saying is material to the issue and not merely cumulative or impeaching or contradictory. And that's a fucking joke. Because in the State versus Carter case, if you have somebody that's trying to impugn me and saying I'm involved in all kinds of illegality, but you have tapes that state completely the opposite of that, that's a problem. But this is why State versus Carter makes this situation so dicey. Number two, discovered since the trial and not discoverable by reasonable diligence beforehand. That means anything that comes up down the line. Okay. And number three, the sort that would probably change the jury's verdict if a new trial were granted. And number one is really the issue. Because when you're talking about a cumulative thing or impeaching or contradictory, that's not good enough. But you mean to tell me that this guy is telling the feds, I did X, Y, Z. You have tapes saying and proving that I didn't do X, Y, Z, but yet I can't use that because it's contradictory? That's a problem. And that's the way that this law is weaved. So in practice, if the prosecutor suppresses or fails to disclose evidence that is material to the defendant's guilty verdict or sentencing or influences the credibility of a witness, no matter whether the prosecution is in good or bad faith, intentionally or inadvertently, the defendant can use Brady material to get a new trial. See United States versus Bagley. The prosecutor, however, is not required to disclose the entire files, but only impeachment and exculpatory evidence to the defense counsel, regardless of whether the evidence is in their possession or not, or whether they are asked to do so or not. And to be more specific, the prosecutor has an affirmative duty to search their files and the files of law enforcement officers who work on the case for material evidence. As to the defendant, they are required to demonstrate that if such material evidence is disclosed and used effectively, it might affect the outcome of a trial or undermine confidence in the verdict. See Kiles versus Whitley. And so that's sort of the thing. When the prosecution sits down, they have to literally hand over everything to the defense, okay? That can help them win their case. They have to give them anything that helps them defend themselves. But the rub comes in is because the judge can decide that. And that's bullshit. And it's bullshit. It's the way that the law is worked. And so the Brady material has three components. The evidence at issue must be favorable to the accused, meaning the defendant, either because it is exculpatory or because it's impeaching, which is weird because it's almost like a hypocritical sort of law, because on one hand, they're saying, okay, well, if it impeaches a witness, then you have to hand it over. But then when you go back up to the top, it basically says that you can't do it. So which one is it? Material to the issue and not merely cumulative or impeaching or contradictory. So we have two sides of it. So there's a very fine line that a jury or a judge or a prosecution and defense have to walk when they're doing this material. Let's see. Okay, once one of the above elements is in contention, the Brady violation is established. Okay, Brady material. A, they have a duty to disclose. Constitutional requirements. The prosecution has a constitutional duty under the Due Process Clause to disclose evidence if it is favorable to the defense and the material to the outcome of either the guilt, innocence, or sentencing phase of a trial. Okay. B, applicable proceedings. The due process right to disclosure of favorable material evidence applies to guilt, innocence determinations, and sentencing. Non-disclosure violates due process where the evidence is material either to guilt or to punishment to sentencing phases. Brady materials may give defendants the right to exculpatory evidence for suppression hearings, holding that Brady applies to suppression hearing involving challenge to truthfulness and allegations and affidavit for a search warrant. Okay. There is not a consensus among federal circuit court judges as to whether or not Brady applies to suppression hearings. C, favorable to the defense. To trigger the prosecution's duty under due process clause, the evidence must first be favorable to the defense. Okay. And that right is broad. Favorable evidence includes evidence that tends to negate guilt, mitigate an offense or sentence, or impeach the truthfulness of a witness or a reliability of the evidence. So, under this predicate, you should be able to present tapes to a jury that refutes a witness's testimony. Am I right or am I wrong? All right. Look at the case of Merlino or Frank Pasqua in the Korea trial. Same sort of thing. The defendant does not have a constitutional. Wait, hold on. Okay, hold on. Let me go. Favorable evidence includes evidence that tends to negate guilt, mitigated an offense or a sentence, or impeach truthfulness of a witness's reliability to the evidence. 4, discovery. Discovery in exculpatory evidence. Some generally recognized categories of favorable evidence are what we're going to talk about. Impeachment evidence. The courts have recognized that a favorable evidence includes several types of impeachment evidence, including false statements of a witness, prior inconsistent statements, bias of a witness, threat of prosecution if a witness does not testify, reversible error to preclude a defendant from cross-examining a witness about pending criminal charges, which gave the state leverage over a witness. But we see in federal case after federal case after federal case, you cannot bring up the shit that that they beat women, that they're junkies, that they stole from people. You can't bring any of that up. This is why I'm telling you the RICO laws are so fucked up, because they bypass all of this bullshit. Witnesses' capacity to observe, perceive, or recollect. Failure to disclose a state's witnesses has been hypnotized. Yeah, okay, whatever. Defendant has the right to cross-examine psychiatric evaluations of a witness. Impeachment information may include psychiatric treatment, witness records that were made part of the record on appeal, blah, 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 blah. Prior convictions and other misconduct. And there's a significant subcategory of impeachment. And it's evidence undermining identification of a defendant, evidence tending to show guilt of another, physical evidence, like a gun being used in a shooting that was inoperable, statement of co-defendant did not mention that the defendant was present or participated. So once again, we go back to Rubio. He said on tapes, Joey Merlino won't get involved in any sort of criminal activity. It's ridiculous. But a judge doesn't allow those tapes. Why is that? How, under discovery, that would be huge. Because your star witness, who was a wife-beating junkie piece of shit, or Anthony Pergiano, who had ripped off some 24 motherfucking people, that should be brought up in a court of law. In addition to being favorable to the defense, evidence must be material to the outcome of a case. Gee, I don't know. A guy saying, hey, he won't get involved in no illegal shit with me, that should be relegated to the outcome of a case. Evidence is material and constitutional error results from non-disclosure. If there is a reasonable probability that the evidence had been disclosed to the defense, the result of the proceeding would have been different. And that's so on an appeal. If let's pretend Joey's going to fight the case again, then that would have been based on his appeal. That information had been suppressed about the informant in the case. The defendant does not need to show that more likely than not, a preponderance of the evidence, he or she would have received a different verdict with the undisclosed evidence, but whether or not its absence in the defendant received a fair trial. That is a trial resulting in the verdict worthy of confidence. The reasonable probability of a different verdict is shown when suppression of the evidence undermines confidence in the outcome of a trial. Okay. The materiality standard is not a sufficiency of evidence test. The defendant need not prove that after discounting exculpatory evidence in light of the undisclosed favorable evidence, there would not have been enough left to convict. Instead, the defendant must show only that a favorable evidence could reasonably place the whole case in such a different light as to undermine confidence in the verdict. And that would be the basis of his appeal if he had been convicted of this. But he never would have gotten there. So there is no set procedure governing how prosecutors must comply with the Brady Rule. Courts will enforce the Brady Rule by ordering the prosecutor. Now, this is where I need you guys to pay attention. And I'm sorry about all the legalese, but this is important because I don't think anybody's ever talked about this. Courts enforce the Brady Rule by ordering the prosecutor to disclose certain evidence or vacating convictions when a Brady violation is established after a trial. However, in the federal system, and this is what we're talking about, in the federal system and in most state prosecutors' offices, there will be written manuals or guidelines that set forth what prosecutors must do to comply with Brady. The Department of Justice, for example, has a section devoted to Brady compliance in the United States Attorney's Manual. Sometimes the Attorney General's offices also issue guidance memorandums to line attorneys about Brady. One example is a famous memorandum issued by Deputy David W. Ogden, sometimes called the Ogden Memo, and that specifically outlines the steps that prosecutors should take to comply with Brady. In federal cases, prosecutors tend to comply with Brady by including favorable evidence among its discovery productions made pursuant to Rule 16. You guys have heard me talk about that, and that is the Federal Rules of Criminal Procedure. It's rare, however, that a prosecutor will specifically identify any document or piece of evidence in the discovery as Brady material. So, for example, when a prosecutor sends your attorney a disk or a USB hard drive or another medium containing a large volume of apparently incriminating information, some favorable evidence may and probably is buried among the unfavorable evidence. So you're getting bad shit and your good shit, but you got to sift through to find the good shit. Unfortunately, there is no rule requiring prosecutors to specifically identify Brady information. Thus, it is generally up to the defense attorney to carefully review any discovery production to make sure that no favorable evidence is overlooked. Federal prosecutors also sometimes draw a distinction between what it calls Brady evidence and what it calls Giglio evidence. Giglio evidence is sort of a subspecies of Brady evidence and refers to evidence that impeaches the prosecution witnesses as opposed to proving the defendant's innocence. So, for example, evidence that the lead FBI agent in a case was disciplined for violating FBI rules is probably going to be considered Giglio evidence. Okay. Alternatively, evidence that the prosecution witness was offered immunity or some other benefit is going to be Giglio evidence. But in principle, there's really no difference between Giglio and Brady evidence. Prosecutors often rely on this distinction to just justify a disclosure of Giglio. And it's not uncommon, for example, for prosecutors to withhold Giglio evidence until a few days before trial. Although many, prosecutors are contentious and they'll comply with Brady, obligations voluntarily. The real truth is that Brady violations are frequently happening in the federal criminal system. And that really comes from an unsettled area of law regarding whether materiality, which is whether or not the evidence will make a difference at trial, is a condition for prosecutors to disclose favorable evidence of information. Sometimes they don't do it. Some courts hold that all favorable evidence should be disclosed to the defense regardless of the materiality. Other courts, however, believe that only material evidence needs to be disclosed. So when a prosecutor is tasked with judging whether or not a piece of evidence is material, it becomes far too easy for any individual piece of evidence, except for the smoking gun evidence, to be deemed not material. It's sort of a sleight of hand trick that they use. So there's 7 types of exculpatory evidence that can trigger a Brady violation. The Brady rule applies to all types of evidence a defendant may be able to use to protect himself or herself from a conviction. And some of those examples would be evidence of police misconduct, right? Another one would be evidence that somebody else committed the crime. Number 3 would be records that suggest you didn't commit the crime. And that's like saying a police report or other records suggest that you didn't commit a crime or may have not committed the crime. And it's also something you're entitled to know. Prosecutors should, and they have to disclose those records. And if they don't, that entitles you to legal remedies to appeal. Physical evidence that casts doubt on your guilt. So along with documentary evidence and any physical evidence that casts doubt on your guilt is highly likely to be material and exculpatory. And that would include anything from a weapon used to commit the crime in question to a piece of property that you allegedly stole. Number 5 is the one that I love. And number 6, information about a deal with an informant or witness. If any of the government's witnesses received a deal in connection with their decision to testify, this is key information that would have a major impact on the judge or jury's decision. This means that defendants are generally entitled to the disclosure of this information as well. Now, how do the feds get around this? Because one of the things we've talked about all the time on this show is when they're asked under cross-examination, have you been paid for any of this? Well, no. And they're halfway telling the truth because the government doesn't pay them money back until the end. But secretly, they do pay them. But technically, they do it in a way where you're putting out money and they're paying you back. But we all know how this works. They're paying these guys a lot of money. They're getting them cock implants. They're getting their tits reduced, getting new teeth so they don't look like a fucking lizard, et cetera, et cetera, et cetera. But they always ask them, are you being paid to testify? No. Have you been promised anything as a result of this deal? No. Just when it comes to sentencing, they could lessen the burden on me, which means the government isn't saying they're going to do shit for you. But the little sleight of hand there is, yes, when it comes to sentencing, you're going to get cut. You're going to get a break because they never signed their cooperation deal until usually afterwards, or even if they sign a cooperation deal beforehand, they're promised nothing. But secretly, they just know. Because nobody in their right mind is going to give up all of this shit for nothing, right? Number 6, information that discredits a state's witness, along with the information about a deal. You guys, this is the one I really want you to pay attention to. Along with information about a deal, any other information that discredits a state or government's witness could also trigger for the prosecution's obligation to voluntarily disclose information. For example, if a witness changes his or her story on the witness stand after giving prosecutors a pretrial statement, failure to disclose that constitutes a Brady violation. Now, I've been in a lot of organized crime trials, and I have seen this Brady violation non-fucking stop. It happens all the time. There have been more witnesses, and there's some that are on YouTube right now that have committed Brady violations. They say one thing to the prosecutors while they're lining up their deal, then they get on the stand and they say something else. That's a big problem. That's a Brady violation. But yet, more often than not, a judge just doesn't do anything about it. All right? That's just reality. That's just, and listen, I'm not pretending I'm a lawyer. I'm sure I might be getting this stuff all comes from law books. So I don't want to sit here and say everything is 100% right, but what I am telling you is that this happens all the time. And it's very easy for people to sit on YouTube and say, well, this, look at the law books, see what's right and what's not. Number 7, information that casts doubt on an alleged victim's testimony. Information that casts doubt on an alleged victim's testimony can also trigger a Brady rule. This includes, but is not limited to, prior inconsistent statements, evidence that the victim is lying, and evidence that the victim has made similar false allegations in the past. See Greg Scarpa's girlfriend. That's how you can use that. When she sat on the stand, oh, he was Mississippi burning and he was in Mississippi doing this and all lies. All fucking lies. John A. Light, all fucking lies. Mikey Scars, all fucking lies. Sammy Gravano, all fucking lies. But a judge gets to decide. That's why there's always these crazy sidebars in federal cases. But it's important to keep in mind that judges examine possible Brady violations on a case-by-case basis. So if you get somebody like federal Judge Sullivan, who was in Joey Merlino's case, he wasn't going to look into it. No, it's just wasting time. Let's just keep going. But those are important things. If you have a fucking government informant who's lying, who's saying all of this shit, well, and then you've got the tapes that prove Joey wasn't involved in what they're accusing him of, right? And at the end of the day, we know how that trial worked out. Joey ended up pleading guilty to gambling. But what does Rubio do not a month after all of this bullshit and he gets a sweetheart fucking deal? He goes on YouTube and starts lying. And he says, oh, I framed the guy for arson that didn't do it. Then gets dragged back into federal court by Judge Sullivan because he wants to know why, after the deal they gave him, this motherfucker is saying that he framed somebody for arson. But do they look into that? No, not at all. Sullivan just says, well, why did you say that? Is that truth? Because that can bring everybody back into court. Sullivan did nothing. He did nothing. That's a problem. Whether or not he liked Joey Merlino really it has no merit. But the reality is you're a judge. And yes, you cannot punish after the fact. I get it. But I can only imagine Sullivan sitting at his desk saying, Jesus Christ, we just gave this guy like the sweetheart deal. We know he got caught lying on the stand a bunch of times. Now he's making a mockery out of the federal system by basically saying he framed somebody for arson who we put in fucking prison, and he does nothing about it. That's what I don't understand. Oh, no, I was just saying that, Your Honor. Oh, okay, well, it blows my mind. And a lot of these people that sit on fucking YouTube and they talk about organized crime and they talk about these indictments, they don't understand the legal system. They've never sat in a courtroom and watched a mob trial and see how fucking warped this shit really is. And I understand the argument people make. Well, if you're not involved in the streets, you don't get dragged into jail. I know people who have just said hello to somebody and been fucking put in prison. They say hello to them at the wrong fucking time because they're wearing a fucking wire and they're subject to a conversation that they're really not involved in, but they sit there and talk anyway because they don't know that they're being taped, and that's what happens. Innocent people go to jail every fucking day. How many fucking people have they put to death in this country that didn't rape somebody, didn't murder somebody? How many times a year do we go through this fucking bullshit where some motherfucker on death row wants a fucking simple DNA test, they do it, oh, guess what? You just did 40 fucking years for no reason. But then there's the opposite side of that where courts are refusing to do a simple DNA test. Well, if you raped 64 people, we're going to run your fucking DNA, and if any of it matches, you're fucked. We're going to electrocute you. That's the end of it. Fine. But in some of these jurisdictions, like the rednecks down in Florida, the rednecks in Texas, won't do it. They will execute a certifiable retarded person. That's the way that those Republican places work. That's what they are. I hate to say it, they're Republicans. Eye for an eye. The Bible is the law type of bullshit. And I get it. I understand retribution. Goes back to the Old Testament. I totally get it. But if you won't do a simple fucking DNA test because you're afraid that it's going to come back that you put the wrong motherfucker in prison, especially if they're African American, they don't want to do it. That's the least they can do. And guess what? If it comes back they killed 64 people, fine. Fuck them. Blow their head off. I don't give a fuck. But if there's any shred of doubt that somebody didn't do that, you have a fucking human duty to do it. But because, inbred states like fucking Texas and fucking Florida don't give a shit, that's what they do. How many people have died that didn't do something wrong? And so the only thing I'm arguing, and I'm sure I've pissed off all my fans in Texas and Florida, but at the end of the day, that's the reality. And a lot of people don't give a shit. It's not their problem. But if it was you, you would feel differently. How many people have we seen exonerated after 60 fucking years? What? And people are going to argue, well, they got like $30 million. What the fuck can an 80-year-old do with $30 million? Most of them are dead within 2 years of getting out of prison. And so my only argument is you can't always use the fucking argument and excuse of, well, if you weren't involved or weren't with these people, it wouldn't happen. Bullshit. Ask that to African Americans who get pulled over for no reason and get beat half to death for no other reason. That's my point. Anyway, other types of evidence may constitute Brady material as well. And the types of evidence listed above may or may not qualify depending on the facts at hand. So in other words, the judge has discretion. Advocates, including prosecutors, take into account issues of admissibility in assessing the strengths and weaknesses of their cases and preparing for trial. But they do not make those determinations. Guess who does? The courts and the judge. Deciding whether or not a piece of evidence would help a prosecutor's case is likely to be admitted is not the same thing as deciding it is not admissible and suppressing. It's so that it becomes available to help the defendant's case. Allowing prosecutors to make that decision is bullshit. Allowing prosecutors to make that decision invades the province of the court, and that violates the living fuck out of the civil rights of defendants to make the same determination that prosecutors are entitled to make. So it's not fair and balanced. Prosecutors are allowed to submit or omit, to give and to take away whatever the fuck they want, and leaving it up to a judge to decide if the defense decides to fight back. How is that a fair and balanced system? Prosecutors have a duty to hand you everything that can help you, except they can decide what they put in and what they don't. And then when the defense finds out about it and they want a Brady violation for it, the judge gets to decide. The judge decides. So I take you back to Joey's case because it's one that we talked about all the fucking time. If I put any of you on trial, let's pretend you're all Joey for a second, and I'm the fucking informant in the case, and I say all of this crazy shit, okay? And let's say I testify before a jury. All right, maybe some of you are the jurors too, and all you're hearing is organized crime, mafia, his past, but yet you can't hear anything about the witness's past because it's suppressed. You cannot hear about any crime he committed, although it should be Brady material because the prosecution has the goddamn civil obligation to put that out. But the judge can decide whether or not that's relevant to the case. I'm sorry, but somebody who is a junkie, beats women, committed crimes while under the jurisdiction of the FBI, those are all things that should be brought out in front of a jury. Because it refutes the plausibility that this is an honest person. Let's pretend you're a jury. And I'm somebody they bring in for murder. I'm going to give you two scenarios. They have no DNA, okay? But they say the following. Well, he has 12 or 14 different charges for stalking different women. Now, a jury hears that. That's going to lend it's going to weigh the scale towards, well, he kind of stalked women. I mean, it's possible this woman was like killed and whatever. You may not have any DNA, but you have that evidence that I used to stalk women. It shows a propensity to be goofy, to just be somebody that could do that, right? But let's say the one witness who says they saw me enter the apartment has a history themselves of stalking people. And let's say they also have on their record sex offenses. A jury doesn't hear that. Or let's say this person who's testifying against my character has embezzlement charges, theft charges, harassment charges, stalking charges themselves. A fucking prosecutor can get that suppressed. That is relevant information that could lend itself to impeaching a witness. And that's all we're talking about. Because every fucking time I've been to an organized crime trial, that is a big area of contention, Brady material in the tapes. Because to me, a man saying the following: I've tried to get him involved in every crime imaginable. He won't get into any crimes. He told me to fuck off. Everybody I've talked to, which I have wiretaps of, have all said the same thing. He wants nothing to do with any illegality. Leave him the fuck alone. Open and shut case right there. Open and shut case. Or I don't know, at every turn you say that somebody was involved in orchestrating fraud, but yet there's no check ever written to his name. There's never any money. Well, how did you pay him? How do you get paid? You know everything. How do you get paid? Show me where he got paid. They couldn't do that either. Oh, well, he had 10 or 12 doctors writing these scripts. Okay, how come not a single fucking one of those doctors was ever subpoenaed? How come not a single one of those motherfucking doctors got their law license taken away from them? In an era where pain pills are through the roof and everybody's dying, you mean to tell me that all of these doctors who are writing all of these fraudulent prescriptions and then kicking back the Joey on top of it, not a single fucking one of them was fired, shit-canned, or had their license removed, and yet didn't have to testify? Your case is so fucking strong that not a single motherfucking one of these cocksucking doctors who did this shit have to testify in federal court. To me, that's fucking odd. That's odd. That's like the shit happening to Michael Jackson and them not bringing that goofy fucking doctor that was giving him milk or whatever the fuck it was. The sleeping shit. Oh, well, we gave it to him, but we don't need to put you on the stand. You're good. It's bullshit. And I'm not defending Joey Merlino. I'm simply bringing it up because that is a case that we have talked about for 2 years, 3 years on this show now. And that's my point. The system is flawed, right? Nothing's perfect. I get it. But when it comes to sentencing phases, and this goes to what we were talking about earlier when I kept saying sentencing guidelines and et cetera. You could, even if you are accused, let's say you're accused of murder 10 years ago. When you get to the sentencing phase of your trial, the government and the prosecution can bring that up. And you look at them and say, but I was acquitted of that. Acquitted means a jury didn't believe you did it. There's no conviction there. But yet, when it comes to showcasing your character, they can use that as leverage against you. And that's not right. That's almost double jeopardy. Oh, so if I was accused of jerking off in a cup, you can bring that up. All right. And so you think, being a defendant, they're like, okay, well, they're going to do this to get the sentencing guidelines higher, to get me more time, to show a propensity that I haven't learned my fucking lesson. But yet, when you go to impugn the witness and say, well, by the way, the witness committed 16 rapes. Nope, can't even say that. You're not allowed to say that. Why? Why? That's what I don't understand. And Joey's not lying when he tells you, had they been able to play those tapes, he would have been in and out of that court in 5 minutes. It would have been over with. But once again, prosecutors can share and take away whatever they want. And if the defense sees it and says, well, wait a minute, the judge gets to decide. And in my opinion, the way that you level the playing field is if you can impugn me, I can impugn you. Let's impugn each other till we fucking die. That's the way it should be. That's the way it should be, but that's not the way the legal system works. And listen, there is some truth to, if you're minding your own business, nothing bad happens, right? Sure, that's not true, but The reality is sometimes bad shit happens to good people. Who you're around should not determine what you get indicted for unless you're up to something. And I agree with that. But I think it's foolish for anybody to talk about the legal system in that way, especially because you're saying based on somebody's past, what do you expect? Well, no, I expect a system to not hold my past against me, but that's what they do. That's exactly why in a lot of situations, guys get hammered. It is what it is. The system is designed to bankrupt you or to force you to give in or to cooperate. They want you to either, the feds always want you to believe you have two options, plead out or rat. And it's just, you have more options than that. But the problem is, not everybody has that kind of money. And the truth of the matter is, the money that you put up for a lawyer is going to weigh whether or not you go to prison the rest of your fucking life. Because how many times have you guys, and I can say for myself in my case, attorneys and prosecutors are buddies. They're pals. They sit in there and they laugh about the charges and they're like, oh, come on, let's work something out. He does this, you do this. Prosecutors don't give a shit what you've done. They want those stats. They want that conviction rate because they want to run for office. Or they want to brag, or they want to, listen, if anybody believes that a prosecutor is so hardcore and they hate fucking criminals and this is what they were born to do, they're Johnny Law cocksuckers, it's not true. I've seen it myself. I've seen prosecutors and defense attorneys chumming it up, laughing, talking about going to a fucking Sunday football party. And the guy says, well, look, he did a bad thing, so I need this conviction. We've got enough, so it's a negotiation. How can you be somebody who hates bad people and crime so fucking bad and then negotiate? It's bullshit. And I'm going to tell you the secret. Anytime they offer a plea deal, they got nothing. They have just enough. And I always weave it with the offered plea. And an offered plea is which I took, which states, based on the evidence you have against me, it's probably likely that I'm going to be convicted, but I'm not going to admit to doing a fucking thing. That's what an offered plea is. You can maintain your innocence, but you're acknowledging that, you got some things that are really bad for me and I'll probably get convicted. And that's the way it goes. And so when it comes to tapes, to sum this all up, they should be allowed, but often they're not. And often, listen, I can understand if a guy is talking on a tape psychobabble about banging a fucking dolphin in the ocean. Okay, well, that really has no relevance to fucking racketeering. I understand that. But when a guy is talking about his own crimes he's going to commit, talking about a guy who they're prosecuting in a huge fraud case, and a RICO case, a racketeering case, and he's saying, I've tried to get this guy to break the law 1 million times. He says, fuck you, get away from me. I don't know, maybe that's evidence that, that the guy didn't do it. Because this wasn't just one tape. This was dozens that he said this. And then once again, I always point out, for all of you people that like informants to some extent, who said, oh, they've changed. Look at Rubio. He's a great example. He's just one of dozens that have done this, where he comes out and admits to framing people. Thinks this shit's funny. It's not. And that's why he got hauled back into federal court. Because he made a mockery of the judge and the system. But the judge didn't do shit about him. He just slapped him on the wrist and said, whatever. No, it doesn't work. It shouldn't work that way. Because as much as the definition when it comes to law of proving without a shadow of a doubt that you did something, I don't know, maybe a scrupulous fuck sitting on the stand lying nonstop, lying after the fact. I don't know, maybe that should be a green light that something's fucked up. But what the fuck do I know? I'm just a podcaster. Anyway, that's it. We'll be back on Mob Talk Radio.